interdisciplinary, and then doctrinal approach in contemporary legal research. I'll be more interacting. I'll be more, trying to, provide certain important, feedback, and certain important, not as a feedback, but certain important, input, especially in the context of interdisciplinary research, how exactly it has to go ahead. And that is very important in this contemporary time, because interdisciplinary research that has become now backbone not only in the legal education but in other disciplines as well. Interdisciplinarity has become very important, because now entire world has, come together and has become, as a global village, where many important issues, those have merged, submerged with each other. Even the different sectors merge and governance, more specifically, research, it can provide, indeed, uh, all right. So hope I am audible.
Better, sir, now.
Yes, sir, now you are audible.
So my screen is visible. Dr. Bismi, my screen is visible. I think your voice is not coming this side. Am I audible that side?
Yes, sir. Yes, sir. You're actually sharing the screen,
Yeah.
not the PPT.
Yeah.
So
Yeah, I'm just sharing my PPT.
yes, it's visible now.
Okay, thank you. So let's go ahead with our discussion today. Especially, I just wanted to have this discussion more, interactive. If you cannot hold your questions, please stop me and ask me questions in between. Have your input as well. Have, your important additional point as well while we are discussing and while we are exploring this particular very important area with reference to interdisciplinary and doctrinal approach in contemporary legal research. So when we are talking in the context of this contemporary interdisciplinary research, now let me put forward at this juncture, and especially in the context of interdisciplinary approach, and how exactly now in almost every domain, almost in every sector, it may be the legal, the education, it may be public governance, it may be business, it may be information and communication technology, it may be medical science or medical jurisprudence. You will find that, and you will come across that these all different disciplines are now growing with the help of other disciplines, doctrines, other disciplines knowledge base, other disciplines approaches are being taken into account in solving many important issues. And when we talk about law is also not devoid of that interdisciplinary approach or that interdisciplinarity, or more specifically other disciplines knowledge base or other disciplines approaches that is being taken into account to resolve the many problems of the society. And more specifically, when we are talking about the law, and we say that law is not exactly independent discipline, law is not exactly growing on its own. Law is ultimately growing based on the societal experiences, based on the societal requirements. Law is also growing based on finding out the solutions which are some or the other way hidden in other disciplines. Let me tell you at this juncture, when we are talking in the context of, hope I am audible that side?
Yes, sir, audible.
All right. Please remind me if I am not audible, because I don't want to have any vacuum in the discussion. So when we are talking in the context of this 21st century, now you will find that in this contemporary time, when we are talking about in the background of this globalization, when we are talking in the context of, in the background of this mixed economy, or in the background of this free trade, or in the background of this foreign direct investment, or in the background of transboundary, we can say the trade and businesses, or when we are talking in the context of more specifically information and communication technology, which is evolving and which has evolved to a large extent, which is impacting in almost every domain, including legal education, including the way of settling the problems. You must have already observed that how exactly now even the problems or arbitration process is also happening through online, or more specifically online dispute resolution. So you will find that the other disciplines, including information and communication technology, and majorly in this 21st century, you will find that no sector or no discipline is devoid of having impact of this information and communication technology. You take the example of medical jurisprudence, or you take the example of more specifically this medical, or more specifically these health services. You will find that now the more specifically this medical jurisprudence, or more specifically health services, are also now based there, more services based on these digital medicine aspects. Now sitting one particular surgeon in the United States of America is performing the surgery of the patient who is in the hospital of India or Indian continent. He's directing through with the help of this information and communication technology how exactly incision, or how exactly this operation or surgery cut it has to be performed on the patient. Or more specifically, if you will see carefully, this how exactly this robotic, or more specifically, this artificial intelligence, it has been imbibed in this medical jurisprudence, or health services. So in 21st century, you will also find that this interface of information and communication technology, it has come to a large extent and larger extent. So law is also not devoid of that. Now earlier we have said and we have seen, and even the jurisprudence classes, we have already seen that different important theories of legal norms evolution, right from sociological school of jurisprudence we have seen historical school of jurisprudence, we have seen natural school of jurisprudence, we have seen analytical jurisprudence based on John Austin's very basic idea, where we have seen varieties of ideas where it has been stated that law is growing based on the societal experiences, law is growing based on the popular opinion, law is growing based on command of the sovereign, law is growing based on more specifically the grand norm which is coming from a particular a particular system. But some or the other way, now 21st century is growing and marching ahead with certain new important ways of thought, where we can say that now law is growing with the growth of technology. And that is one of the important interface of interdisciplinarity, which is impacting to larger extent the legal research, legal domain, legal norms, more specifically doctrinal research. It is impacting to a larger extent. This advent of information and communication technology is impacting to a larger extent. Kindly pardon me if my slide is not moving in this session, because my session does not require any kind of slide, but just for the reference of the audience, I kept certain slides in front of you. So kindly pardon my slide if it is not moving ahead. So what I am saying here, this 21st century, now law or legal discipline or legal research is more and more having impact and influence from the side of information and communication technology, from the side of technological growth and technological advancement. Let me cite here very important, the scholar and jurist, and his opinion, that is Mr. Lee Lowinger. He has stated that earlier we have stated in his opinion, I am saying, and I am quoting him here in this particular session. He stated earlier that it has been stated that necessity is the mother of invention. And this is the general statement, general phenomenon, which he has quoted, he has stated, Lee Lowinger, one of the famous, the jurist and author of more specifically clinical legal education and more specifically empirical legal research. So he stated that in earlier century, we have stated that necessity is the mother of the invention. But he further elaborated and extended that particular his version and stated that now invention has become the mother of necessity. And it is true. It is reality that we cannot lead our life without the interface of smartphone. We cannot lead our life without, the alarm set in our smartphone. We cannot, have, any kind of, proper systematic or very strong, communication without the help of email transaction, or without the help of information and communication technology, or without the help of Twitter handle, or more specifically, Facebook or WhatsApp, or we cannot imagine now the life or that which has been already categorically stated in, T. Damodar Rao, more specifically life. Life is not mere animal existence. That particular version I am remembering at this particular juncture. So now we cannot imagine that particular life without the interface or that dignified life of human being without the interface of technology or without the interface of information and communication technology. So information and communication technology, internet, Facebook, WhatsApp, Twitter, social media, it has tremendous impact on the growth of legal norms as well. You take any example, even if till today, till yesterday, whatever legislations which are coming and growing and legal norms which are coming and growing by any legal system all over the world, I am telling, including India and Indian continent, I am telling, you will find that each and every legislation is having some or the other way the interface with information and communication technology. Now you must have also seen recently how even information and communication technology, because I am here talking about how other disciplines knowledge base is growing or is making growth in the legal norms or new kind of legal research or new kind of doctrinal legal research or doctrinal research. You must have recently come across and you must have seen how, to a larger extent, our public governance, our constitutional governance, our human rights, our, more other disciplines are having tremendous impact of information and communication technology. Let me provide you here the example how other disciplines knowledge base is impacting the interpretation of the Supreme Court as well. How it is impacting or bringing out something new interpretation. As we have already stated that the doctrinal research or doctrinal legal research is nothing but, verifying the legal propositions, which has been already stated, in the rulings of appellate courts. So when we are talking about those rulings of appellate courts or the opinion which has been, propounded by appellate courts, so taking the help of those important opinions, those important legal propositions, and taking the help of other disciplines knowledge, something new is also growing. Something new knowledge base is also growing. Nothing but the new legal research or legal norms are also growing. I'll provide you the example at this juncture. We have recently seen in 2019, and I'm sure almost all of you must have, come across this particular judicial pronouncement, which has been propounded by single judge bench of High Court of Kerala, that is Justice Asha. In the case of Fahima Shirin versus State of Kerala in 2019, one of the important and very landmark judgment, which is going to become, the landmark and the trend setter for the entire country or for the growth of legal jurisprudence or constitutional jurisprudence. How new interpretation it has been brought in this Fahima Shirin versus State of Kerala in this particular case, where you will find that the interface of information and communication technology, interface of internet or access to internet, or interface of human right discourse that has been infused in providing, remedy to that aggrieved, the student of State of Kerala, that is Fahima Shirin, along with her other, inmate or other friend Ritu in this particular case. When these two students or when the student, they were stopped from using the internet or using the mobile phone, using the laptop, in the evening hours in the hostel, and from the hostel administration, when it has been restricted, when it has been stopped, they approached to the High Court of Kerala. They approach saying that it is clear-cut violation of our right to life, right to education, which is guaranteed already in our Indian Constitution. It is also a violation of right to know, right to information, which is guaranteed in Article 19, Clause 1, Subclause A of Indian Constitution. These are legal propositions based on doctrinal approach. But through this doctrinal approach, how new interdisciplinary approach that has been infused, that particular aspect we have to see and understand for further growth of legal research. So many contentions, those were kept forward or those were put forward before the High Court of Kerala, before Justice Asha in this particular case. And how beautifully, wonderfully she has brought the analysis from, international legal instruments as well. Other disciplines knowledge base as well. Very wonderfully she has brought and crafted this particular new version that access to internet is also human right, and it will facilitate right to education, and it will facilitate right to life, and that has to be interpreted within the four corners of our fundamental rights. And she has referred, see how, categorically you have to bring something new interpretation, because many landmark judgments are the best examples of doctrinal approach along with interdisciplinary approach, which is some or the other way reflecting in many judicial pronouncements in recent times. So Justice Asha in this particular case, when we are talking about interface between law and technology, law and information and communication technology, law and education, when we are talking about, in that particular context, we have to understand how interdisciplinary approach is being infused in legal research or doctrinal research. She went back and she referred to human rights discourse as well. She referred to United Nations Human Rights Declaration, UDHR, Universal Declaration on Human Rights. More specifically, categorically, she referred Article 19 of UDHR, Universal Declaration.
So you're not audible?
I think the power went off or something. I can't see.
Am I audible?
Yes, sir. Yes, sir.
I'm so sorry, there was power off here this side. I was trying to connect with my other handset, but meanwhile power has now restored. Hope I am audible now there properly.
Yeah.
Yes.
Okay. So what I am saying here, when we are talking in the context of interdisciplinary approach and how exactly now legal research is growing with the help of interdisciplinarity, we have to understand now recent trends, which is reflecting through even judicial pronouncements. Because long back, Justice Deepak Gupta, not Justice Deepak Mishra, in 2017, indeed, when there were these issues in the context of, this all social media and regulation of social media, when this issue was in front of Supreme Court, he also admitted that now many things, those are being regulated in the society, in different disciplines in the society, by way of information and communication technology. Many businesses and transactions are happening with the help of information and communication technology. Even he has referred, Justice Deepak Gupta, that darknet is also very, very, emerging legal issues presently, where many illegal activities are happening, under the cover of this darknet. So he's shown that particular, some or the other way concern as well, how to regulate this entire information and communication technology, or how to regulate this entire, this cyberspace or this internet. So that is yet another important aspect. But when we are talking in the context of how law is growing or new interpretation is coming, now how new legal norms are being established, those are being established with the help of other disciplines' knowledge. And when I am referring this particular landmark judgment of High Court of Kerala of 2019, where Justice Asha went back and referred certain human right discourse as well, while defining, designing, and bringing out new interpretation with reference to right to life and right to education. Because she referred that this right to education, right to life cannot be properly facilitated unless and until there will not be proper information or proper right to know, if it will not be properly facilitated to the students. She even referred that Article 19 of UDHR, Universal Declaration on Human Rights, which says that, which more specifically says that this right to speak, speech and expression, that has to be facilitated by any means and mechanism. That is the responsibility of state and state instrumentality. Article 19, not Article 19 of Indian Constitution. I am talking about Article 19 of Universal Declaration on Human Rights. It specifically says that freedom of speech and expression by state and state instrumentality has to be facilitated by any means and mechanism. This is the very important, the article of UDHR, which has been referred as one of the important legal propositions by Justice Asha while delivering this particular judgment, while delivering this particular, important judicial pronouncement. Now, when we are talking about how technology or information communication technology or cyberspace or internet is impacting the human right, impacting the constitutional right, or impacting even, the public administration, we have to understand, this particular important judicial pronouncement, which has also cited and quoted with reference to right to education, with reference to right to life. Even Justice Asha, she went beyond this particular, the legal premise which she has quoted with reference to Universal Declaration on Human Rights. She went further and stated that now in this 21st century, and more specifically by way of this United Nations organization work, more specifically non-legally binding document of 2016, which has come by the United Nations Committee on Human Rights, Council on Human Rights, stating that access to internet is also human right of the citizens or the people all over the world. The first time in 21st century, I am telling and referring and quoting here, this particular legal premise, even if it was non-legally binding document, But this non-legally binding document also becomes the obligation on each and every state and state instrumentality which are part and parcel of that particular process of declaration or discussion or dialogue or any kind of conference of United Nations organization. It becomes the responsibility to implement in the domestic legal system. So taking the help of that particular 2016 resolution which had been passed from the side of United Nations Council on Human Rights, Justice Asha stated that in this Fahima Shirin versus State of Kerala, in this particular case, that right to education and right to life, that cannot be exercised unless and until there is no proper information, or no proper right to information is being received by any means and mechanism to the people of the country or to the students. And she has also referred that now in this 21st century, and then more specifically in India, because of the work of this digital India model, because of this work of this Swayam, these all online resources and courses, those are available online. So access to internet is becoming, or that has become, one of the important facets of right to information, or it has become one of the important facets of right which has been guaranteed in Article 19 clause 1 subclause A, that is freedom of speech and expression. Because if you will see other important legal premises or legal propositions by way of People's Union for Civil Liberties versus Union of India in this particular case, where Supreme Court of India has also stated that freedom of speech and expression also goes to the extent of expression through casting of the votes as well. Expression through casting of the votes means casting vote in the election is also a kind of freedom of speech and expression, which is also dependent upon receiving the information. So right to information, which we see by way of 2005 legislation, it is also the slowly grown work of our judicial creativity, which has been at last in 2005 by way of Right to Information Act. It has been institutionalized based on right to information, based on right to know, which has flown through this Indian Express newspaper case, Sakad newspaper case, Romesh Thapar versus State of Madras case, or more specifically the recently important cases like in the context of this Swaran Singh, and in the context of more specifically this Paramveer Singh Saini versus Baljit Singh. We will be talking about those important legal propositions and important the cases. But at this juncture, when we are talking about that how law is growing, now how new interpretation is growing, now we are seeing that this doctrinal approach is also being used by the Supreme Court and High Courts. When they are delivering the judgment, it is also the best example of doctrinal approach. Doctrinal approach with the help of interdisciplinary approach you will find. So here when we are talking about how information and communication technology, how internet, or how exactly this Facebook, internet, social media, it is impacting the new growth of the law or legal research, you have to understand this recent judicial pronouncement. Now legal research or doctrinal research will also provide the new interpretation towards this now recently emerged issues which are sub judice before the Supreme Court of India presently. So those issues can only be resolved by doctrinal approach and interdisciplinary approach. The issues recently which we have seen, And you must have already observed in the context of this recent Internet Intermediary and Digital Media Ethics Codes Rules 2021, which is framed by the Ministry of Information and Broadcasting in 2021 in the month of February. Now, this particular, the rules, it is some or the other way trying to, regulate this entire social media, regulate this entire, cyberspace, which is very important. That is very important to regulate. But if you see carefully, certain gray areas which will be adjudicated upon from the side of Supreme Court, that will be adjudicated upon based on interdisciplinary approach. It will be, adjudicated upon based on, understanding and wisdom of information and communication technology. Understanding the wisdom from the discipline of, the cyberspace. Because this particular 2021 rules, that is Media Ethics Code Rules 2021, which is framed, under more specifically Information Technology Act. Now, this rules indeed has given, tremendous power in the hand of central government to regulate the social media. So central government can provide or can give the direction to any social media house or any particular, internet intermediaries, including, we can say, or even social media houses or social media platform like Twitter, WhatsApp, LinkedIn. Central government can provide the direction that provide a certain information with reference to originator of the WhatsApp message, encrypting and decrypting that particular, we can say the first originator of that particular message. So issues are also here involved with reference to privacy. Issues are also here involved with reference to, more specifically in the context of how far, social media or free speech or freedom of speech and expression through social media, it can be regulated from the side of state and state instrumentality. This is very important to understand and to provide the input in this adjudication process. Because no doubt this particular subject matter with reference to validity of 2021 rules, Media Ethics Code, Internet Intermediary and Digital Media Ethics Code Rules 2021, this related to this particular, issue, 7 and 8, different 6, 7 high courts of the country, they are already flooded with the litigations and petitions. So definitely this particular subject matters will be, clubbed before the Supreme Court of India in coming time. But we have to understand here certain important basic premise from interdisciplinary approach, how exactly new interpretation based on doctrinal research work, it can grow in your research in coming time. All over the world, including European countries, including, the Western countries, and even, now Indian continent, South Asian countries and Asian continent as well, attempt is happening all over the world from the side of successive government that they want to regulate. This is obvious. They want to regulate the social media. They want to regulate the media. Or all over the world governance, they want to regulate this cyberspace. This is the general phenomenon. But at the same time, we have to also understand what kind of legal propositions are also, similarly and parallelly growing, which will also provide something new kind of interpretations to bring in this new doctrinal research or new interpretations or new growth of legal norms. Because European countries, Canada, USA, if you will take example of any country, they want to regulate the social media, including the Indian continent and including the India I'm talking here. that social media, internet, everyone, every successive government wants to regulate, wants to control. But now question comes, how far this free speech, right to know, freedom of speech and expression through cyberspace, which is already recognized, that can be regulated based on, again, I am referring here, the test which has come or which has been propounded in case Puttaswamy versus Union of India, 2017 case, where Supreme Court has also evolved, certain important test based on proportionality, legality, based on more specifically necessity, proportionality, and legality. Those restrictions, if it has to be restricted, if it has to be, imposed upon any kind of freedom, including freedom of speech and expression, then those kind of, even if freedom of speech and expression which is happening through the cyberspace, if it has to be regulated by any legislation, it has to be seen and examined that particular restrictions, restrictions which is being carved out through any particular, the legal norms here. For example, 2021 rules, that is Internet Intermediary and Digital Media Ethics Code rules 2021, it has to be tested based on the proportionality, necessity, and legality. So here, when we are talking about this in this 21st century, this emerging trend where social media, information and communication technology, this entire world government or successive government, they wants to regulate in that particular, context, we have to also understand what important legal norms are also established parallelly, and what kind of legal norms that has to be taken into account while resolving these kinds of issues which are emerging presently or in contemporary times. Long back in Mann versus Illinois, or more specifically Justice Wendell has also stated that, has also brought this particular very important opinion, and that has to be referred, that has to be taken into account while establishing any new interpretation, either by judiciary or as a research scholar or as a teacher of the law or legal discipline or social science. He stated that Justice Wendell, Justice Holmes, they stated more specifically, categorically, that free speech, freedom of speech, and more specifically, not only freedom of speech and expression of majority opinion that should be, supported and that should be promoted, but at the same time, minority opinion as well, or a minuscule number of people's their say as well, should also be facilitated by the governance of the country. Their speech, their free speech, their freedom of speech and expression should also be facilitated by the successive governments of any country. If you will see that particular legal premise, and then if you will examine this recent, the judicial trends and different, legal propositions, you will find that something new is also going to come. Something new is also going to happen. Something new legal research or legal norms or new legal interpretations or new interpretations you can bring into existence. Long back in 2015, we have also seen in our Indian continent, by way of Shreya Singhal versus Union of India in 2015, we have seen how beautifully Section 66 of Information Technology Act, it had been struck down, saying that whatever restrictions which has been brought by way of Section 66 capital A over the free speech by way of any computer resources or internet, how exactly it is grossly offensive, that has not been exactly defined and designed in this particular, the provision or penal provision. or criminal provisions related to criminal law. So if any restriction, if it has to be, imposed upon free speech or freedom or guaranteed freedom or human rights or fundamental rights of the citizens, those restrictions not only be in consonance with that of the given restrictions in our Indian Constitution by way of Article 19 Clause 2, but at the same time those restrictions should also be reasonable. Those restrictions should also be based on legality. Those restrictions should also be based on reasonableness. 2015 I am talking about. The legal propositions which has come, in the Shreya Singhal I am talking about. And in this particular case as well, it has been recognized. And here I am telling you how fundamental rights, human rights, it is also getting impacted by way of information and communication technology. In Shreya Singhal versus Union of India, you must be seeing, and you must have already seen and examined this particular aspect. It has been stated that freedom of speech and expression that can also be facilitated by way of cyberspace as well. So freedom of speech and expression is not only been designed, and it can not only be facilitated by the newspaper or print media, but at the same time it has to be facilitated through cyberspace as well, through WhatsApp as well, through Facebook as well, through internet as well. So see how big statement, how big legal propositions it has come, or it was growing, or it is growing continuously in this 21st century. Taking you ahead, when we are talking about how law is growing with the growth of technology, and how this technological interface, it is impacting in our legal research or in our new interpretations of existing legal norms. So you have to also understand other important, the judicial pronouncement and judicial trends, which will also provide you certain insights to think in interdisciplinary ways, or with the help of interdisciplinary approach. Let me cite here one of the other important, judicial pronouncement, which has come from the side of Supreme Court by way of Swapnil Tripathi versus Union of India in 2018 case. Very important, very landmark case, and it is again with reference to facilitation of right to know, right to information, more specifically legal education. So in that context, the Swapnil Tripathi, one of the students of Jodhpur National Law University, he had approached before the Supreme Court. In the background of Supreme Court, when they hear or they list the new cases on every Monday, most of the time this entry is restricted for the law students, and that had been restricted for the law students in the Supreme Court most of the time, because of security, safety, because of the more rush in the Supreme Court when there are new subject matter are listed before the Supreme Court every Monday. So in the background of those restrictions which has been imposed by Supreme Court of India, the Swapnil Tripathi had approached before the Supreme Court against the Supreme Court, saying that those all proceedings of Supreme Court of India should be made available to the citizens of the country and law students through live streaming to the entire country. Live streaming through social media or with the help of internet, that has to be made known. Means live streaming of the proceeding of Supreme Court should be facilitated from the side of Supreme Court, so that the legal education, right to education, that would be fulfilled of those many students who are not able to approach in Supreme Court for observing the proceedings of Supreme Court of India. And further, it has also been contended from the side of Swapnil Tripathi that live streaming of Supreme Court of India and their proceedings will also facilitate this open court system, which has been one of the important facets of our Indian judiciary from time immemorial. It will also make the citizenry as an informed citizenry with reference to, the judicial decision making of the court. It will also repose the faith of the people of the country in the judicial administration or justice administration, where the people, they can see live to their judges and to their, the advocates who are arguing in front of Supreme Court. In that way, there will be more and more confidence in the justice administration of entire country. So in that context, this petition, when it had come before the Supreme Court of India, you will surprised to know that Supreme Court of India, they had acknowledged and they have admitted this particular petition, and they have also given the directions to the Ministry of Information and Broadcasting that facilitate this live streaming, at least the live streaming of constitutional benches judgment or national importance related subject matter judgment, that should be shown, or those proceedings should be shown live to the citizens of the country. So one side, this right to know, right to information, right to get the education, or right to receive the information, which is one of the important facets of Universal Declaration on Human Right and Article 19 on UDHR. This particular judgment was facilitating and making the interpretation based on those important legal propositions, based on human right discourse, human rights jurisprudence, based on this emerging information and communication technology. You will find that now these fundamental rights and human rights, more specifically access to justice, more specifically dignified life, more specifically right to education, more specifically right to get legal education, it has been facilitated by way of this Swapnil Tripathi versus Supreme Court of India and others, including Union of India. In this particular case in 2018, Supreme Court itself has recognized that this particular live streaming will facilitate the people's right to know, right to information, and it will also provide the way to inform citizenry, which is one of the important backbone of Indian democracy or democracy of our India. So democracy can only grow, or civil rights can only grow if it has been, or if it is being strengthened by the existing legal system. So this was one important, the premise. This was one important, we can say, the legal propositions which has been used, or information and communication technology, and the help of information and communication technology is being taken or is being infused in the interpretation of many legal rights, many human rights, many fundamental rights, many human rights. Go back and see this Paramveer Singh Saini versus Baljit Singh case. That is the case of 2020. When in 2015, more specifically DK Basu case, in 2015 I am telling, this particular version or new version, it has come with reference to this inmate, or with reference to under trials, or with reference to those all who are behind the bar or in the jail, that different human rights for those people that has to be protected, their human rights that has to be protected. So taking the help of these important legal propositions, because in doctrinal research we see, we play, or we generally play with the help of legal propositions only to bring out, or to establish the new legal interpretation, or to establish the new solutions to existing legal problems. So in that context, if you will see the DK Basu 2015 case, which has recognized the human rights, and many more cases as well, earlier cases as well, where guidelines were also issued with reference to the jail inmates and those all jail inmates who are behind the bars, how different human rights that has to be protected from them, including their trial, including their production before the court, and including different important safety measures, their protection measures inside the jail. So with reference to that particular judicial pronouncement, the different legal propositions have come into existence. But if you will see carefully, this particular case, Paramveer Singh Saini versus Baljit Singh, the case of 2020, which was there in front of Supreme Court has come up with something new interpretation, new opinion to protect the human rights of those jail inmates, or those under trial prisoners, or those convicted the people or inmates who are behind the bar, or who are inside the jail, how their fundamental rights, how their human rights, that has to be protected further. So they have also brought something new analogy, or something new important support mechanism with the help of this technological growth. They stated, the Supreme Court in this Paramveer Singh Saini versus Baljit Singh, in this particular case in 2020, they specifically stated that the human rights of those jail inmates, or even the alleged people, or even when the FIR, if it is being registered against any particular person, in that particular entire process, there must be a proper installation of high power, or we can say high power CCTV in each and every police stations of each and every district and each and every town of this entire country. A specific direction, specific guideline in this 2020 case, this Paramveer Singh Saini case that has been issued from the side of Supreme Court, saying that human rights of those jail inmates, or even those people against whom certain FIR being registered, that entire process, it should be properly reasonable, and it should be seen how exactly it is more and more fair process. So to make that more and more fair process in this criminal justice administration, this some or the other way, this infusion of information and communication technology, it has also been imbibed by the interpretation of Supreme Court, saying that this is the responsibility of the successive government, it is the responsibility of union government, and it is the responsibility of Ministry of Home Affairs, that to see and examine, and to have the pilot survey, and to have a proper state steering committee, central steering committee, district steering committee, to establish this a proper infrastructure, to have a strong CCTV in each and every police station, where entire process will be properly and fairly conducted, right from recording the statement of witnesses to the statement of the aggrieved person, and then alleged persons as well. So see how in human right discourse, how in protection of human rights, there is also infusion of information and communication technology. This Paramveer Singh Saini, Shreya Singhal, Fatima Shireen versus State of Kerala, these cases are the best examples where we are seeing and examining that this information and communication technology is impacting the fundamental rights, impacting the human rights, and impacting the different disciplines, including this legal research, including the new interpretations of law as well. Hope I am audible there.
Yes, sir.
Yes, sir, audible, sir.
Right. Now, let me quote here And let me cite here certain other important examples as well. Not only this list which I have provided here, that law and technology, law and education, law and artificial intelligence, law and economics, law and food processing technology, law, media, law, natural resources, law and psychology. But there are other disciplines as well which are impacting the legal research, which is impacting the doctrinal legal research in contemporary time. Even literature in your research work, even the English literature, even the literature, contemporary literature, you can infuse to bring out something new interpretation, to bring out the new solution. You will surprise how it will happen. You will surprise to know how it will happen. We know very well. We are not talking about that kind of literature which has been quoted by Justice V.R. Krishna, Justice V.R. Krishna Iyer time to time in his, judicial pronouncements. We are not talking about, that kind of, heavy literature. But when we talk about how literature can also provide something new insights to think or to bring out the new solution, because literature is also providing certain experiences of the society. If you will pick up any literature, even the poetry if you will pick up, contemporary poetry if you will pick up, or English literature if you will pick up, or contemporary, Indian literature if you will pick up. Now, literature is also providing certain concerns of the society. It also provides certain concerns of some individuals of the society. It also provides the concerns of or plight of those, certain individuals who are committing the suicides because of, overburdened the loans because of, this seasonal, crop failure, which is happening in many parts of the country. So literature is also sometimes impact your legal research. This is also something new, which you can also think while conducting your legal research. And let me quote here at this juncture, Mr. Barack Obama, with reference to literature, how it also impact, the legal research. Obviously, we have seen the Justice V.R. Krishna Iyer, he has also taken, time to time, lot of help while interpreting or bringing out something new interpretation. He has referred, lot of literature. But let me refer at this juncture, Barack Obama, he says, and I quote here at this juncture, he says, and I quote, "The study of law can be disappointing at a time. A matter of applying narrow rules and arcane procedure to an uncooperative reality, a sort of glorified accounting that serves to regulate the affairs of those who have power, and that all too often seeks to explain to those who do not the ultimate wisdom and justness of their condition. But that's not all the law is." He says further, and I quote, "The law is also memory." Barack Obama, he quotes, and I'm quoting him here, "The law is also memory. The law also records a long-running conversation, a nation arguing with its conscience." I'm again repeating this particular statement. The law is also memory. The law also records a long-running conversation, a nation arguing with its conscience. And where we find that particular, the running conversation of the society or that societal conscience, we find in the literature. We find some or the other way in different literature. Excuse me. So most of the time you will find that the current literature also impact the decision making most of the time. Also bring out the new interpretation, new legal interpretation. new doctrinal research, and based on that doctrinal approach, new interpretation can also come. Because we see that, continuously dialogue and discussions in the society. Just when we are talking about now this, continuously we are talking about, recently we have also seen, we have also, experience in this Resham versus state of Karnataka case recently, which has been adjudicated, and obviously it is also flooded with the petitions before the Supreme Court of India with reference to this hijab issue, with reference to this, particular religious affairs, related issues. But at the same time, if you will see carefully, the dialogue and discussions and the public conscience is also, reflecting by way of certain literature. That literature may be reflecting by way of, editorial column, it may be reflecting by way of newspaper, it may be reflecting by way of blogs, it may be reflecting by way of writing poetry, it may be reflecting by way of writing certain, we can say the books or literature. So here just I wanted to say that you have to also keep your eyes open and your mind open related to this long running conversation which nation is also undergoing, which will also provide something new way of thinking, which will also provide new way of new solutions. Now we have seen, because let me propose here and let me keep forward here and in front of you, there are many important issues which are emerging in the society, and doctrinal research, interdisciplinary research can also solve those problems. Based on deductive reasoning, based on inductive reasoning, based on legal reasonings, you can solve those problems quickly. But there is requirement of that kind of willingness. There is requirement of that kind of dare. There is requirement of that kind of, boldness as well from the side of researcher. Now, if you go back and see and examine in the context of this public administration, in the context of this human rights discourse, in the context of this recent evolving jurisprudence in our Indian continent, recently we have seen, and I'm sure every one of you or each one of you must be, aware about this K.S. Puttaswamy's, the legal propositions. K.S. Puttaswamy has provided very important, legal propositions. Justice D.Y. Chandrachud has brought very important and micro level propositions which will be having far reaching consequences and far reaching new interpretation in our, legal research presently. We have already seen this one judgment has impacted substantially the criminal justice administration. This one judgment, when it has stated that right to privacy is integral part of right to life, this one legal proposition has tremendously impacted the criminal justice administration and Indian penal code. We have already seen that. We have already seen how before 2017, I am talking about the doctrinal approach, how it is reflecting by way of this different judicial pronouncement, and how those doctrinal approach and legal propositions you can take into account while bringing out new solutions with the help of interdisciplinary knowledge base as well. So if you'll see and examine carefully this K.S. Puttaswamy's legal proposition, K.S. Puttaswamy's, important judicial pronouncement which recognize right to privacy in the background of this 2016, this Aadhaar, act as well, and then 2009, more specifically the plans of government of India with reference to this unique identification authority of India, which has been established right from 2009. And in the background of that particular background, this K.S. Puttaswamy, he had approached before the Supreme Court that how exactly this personal information should be, in the hand of the state, without having reasonable, process and procedure. And that is also part and parcel of right to life, and right to privacy is also part and parcel of right to life. So that should not be, breached unreasonably by unreasonable, the legal norms or legislations like, 2016 enactment for getting different, government facilities, that Aadhaar that has been made mandate and mandatory. So in that background, we have seen the very fine judicial pronouncement and the legal propositions, crystal clear propositions we have seen by way of K.S. Puttaswamy, which has tremendous impact on criminal justice administration. Once K.S. Puttaswamy settled this particular, point that right to privacy is also part and parcel of right to life, we have seen automatically how partially this section, 377 that has been, nullified with reference to LGBT people, and their rights, recognizing, and after recognizing their right, how exactly this section 377 and application of section 377 against LGBT people, how it had been considered as constitutionally not valid. Not only that, we have also seen, based on this one particular legal proposition, that right to life is also inclusive of right to personal liberty and privacy. Right to privacy is also part and parcel of right to life. And going beyond that, Justice D.Y. Chandrachud, once he has established these kind of legal propositions, like when he stated that right to privacy also includes bodily autonomy. Right to privacy also includes, the information related to person and personality. And that is also part and parcel of right to privacy that cannot be breached without having a just law or without having a proper law to regulate it. So once this legal proposition has come, because here I just wanted to attract your attention towards doctrinal approach, how doctrinal approach can bring a new interpretation. In doctrinal approach, you have to understand those legal propositions of different judicial pronouncements only, or different statutory provisions only, or different appellate jurisdictions, those judicial pronouncements or precedents you have to only understand. Besides, obviously, international, the documents or international commentary or different law commission reports, you generally refer in doctrinal research. But when we are talking with reference to application of legal propositions which is flowing through judicial pronouncements, in this case, Puttaswamy, different varieties of legal propositions emerge. When Justice Chandrachud one side stated in this 2017 case, 541 pages case, he stated that bodily autonomy is also related to right to privacy. This one legal proposition has tremendously impacted with reference to Joseph Shine, or the judicial pronouncement which has come through Joseph Shine, where this, more specifically adultery related Indian Penal Code, more specifically 497, this section 497 related to adultery, that had been struck down by Justice Deepak Mishra headed bench. While declaring that particular section related to adultery based on equality clause, based on Article 14, based on Article 21, based on right to privacy, no doubt those kinds of contentions were kept before the Supreme Court in Joseph Shine versus Union of India. in 2018 case. But while deciding this or bringing out this particular judicial pronouncement to provide the solutions to this particular issue, which has been put forward by Joseph Shine and other people, saying that why only that particular person who is having the relation with that particular wife of that husband should only be penalized. Why not the same provision, and how exactly this same provision is also some or the other way is abridging or violating the equality clause? The same right is not there to that particular aggrieved lady to approach or to file a complaint under Indian Penal Code. So that was one approach, but other approach was there, which was reflected in Joseph Shine, that each and every individual is now having right to privacy, and bodily autonomy is integral part of that right to privacy. Now this is based on the wisdom of each and every individual person, in what way he should lead his life, in what way he should go ahead and lead his life. So based on that one particular legal proposition, where Justice Chandrachud stated one important legal proposition, right to privacy under Article 21 is also guaranteed, and it also inclusive of bodily autonomy. Once it has been stated, that has been very categorically being used in Joseph Shine versus Union of India case. This is one thing. But at the same time, when we talk about how you can play with these kinds of legal propositions to bring out many new solutions to many emerging problems, you have to also keep your eyes and mind open. At the same time, in this 2017 judgment, it had been stated from the side of Justice D.Y. Chandrachud, saying that right to privacy also include freedom of conscience, which is related to more freedom of religion. So he used this particular legal proposition, and he used that proposition further elaborating that each and every individual is having this birthright as a human right, like freedom of conscience. See, this is one important legal proposition from the discipline of social science, from the discipline of, we can say, the discourse, dialogue from the side of social science, or theology, mythology, theology, or from the human right discourse. He has used this particular legal proposition in case Puttaswamy case, saying that right to privacy also includes freedom of conscience, which is the birthright and which is the human right. And we have stated that human rights are inherent, those are right from the birth, and it is the obligation on each and every the state and state instrumentality from each and every corner of the world to protect and observe those kinds of human rights. But here, in this particular case, K.S. Puttaswamy case, the legal proposition, it has come that right to life, right to privacy, inclusive of freedom of conscience, right from the birth. Now question comes, this one legal premise or one legal propositions provides or is going to provide many solutions to the existing problems presently with which we are confronting in the contemporary time. Contemporary time, we are seeing presently with this current running dialogue, discussion and literature, we are continuously seeing in Indian continent as well, in many other continents as well, that contemporary populist government, they are trying to impose, majoritarian opinion on most of the time on, entire country. It is a regular phenomenon. It is not exactly something new or something first time it is happening. So continuously we are also seeing, many instances today as well, yesterday as well, in the Hindu, I was reading that with reference to this hate speech, with reference to this, disharmony, communal disharmony, or blah, blah, blah. Many things we are continuously observing. In the context of communalism, in the context of, polarization, in the context of, even terrorism as well, we are continuously, talking about, and we are facing, continuously these kinds of issues. But the solution of these issues as well, by way of your doctrinal research, is hidden in K.S. Puttaswamy case as a legal proposition, or as a one of the important, strong legal propositions which has been propounded by Justice D.Y. Chandrachud in this particular judicial pronouncement. Now you will surprised to know how exactly these all kinds of particular issue we are going to resolve. You may be asking this question. You may be having this particular question in your mind, that how, this polarization, how this hate speech or communal disharmony, or more specifically, this terrorism, these kinds of issue quickly we can solve with reference to only one particular legal pronouncement. But it is possible. It is very much possible. And I'm going to tell you, and I'm going to, display as well this particular, important legal research, how exactly it can be taken away with the help of doctrinal approach and interdisciplinary approach. K.S. Puttaswamy has stated that freedom of conscience is birthright and human right. Please listen carefully here. Now, freedom of conscience, it does mean, based on international legal instruments as well, and based on human right discourse as well, and human right disciplines as well, human right is birthright, right from the birth. K.S. Puttaswamy has given support to this particular analogy, saying that and bringing this legal proposition where it had been stated that freedom of conscience is human right and right from the birth. Now I am going to tell you, freedom of conscience is also related and relevant, related to profession,
Sir, you're not audible, sir.
Indian Constitution. Now the question is here, freedom of conscience, which is more close to freedom of religion. That has also been stated in K.S. Puttaswamy, saying that freedom of conscience is human right, birthright. Now, question comes whether the state instrumentality, whether the successive government, they are facilitating this freedom of conscience of each and every small child who has taken the birth today. Today, I am sure, as per the medical jurisprudence, almost 20,000, 30,000, newborn child must have taken birth. kind of right and this kind of freedom of conscience right from the birth as a human right. So it becomes now responsibility of state and state instrumentality, including parent, to facilitate the free choice or free conscience, to keep that particular, conscience of each and every small child. He may be from any religion. He may be from any religion, but it becomes the responsibility of the state as a fundamental right, guaranteed fundamental right in Article 21. This is now deductive reasoning I am using in this doctrinal approach to bring out something new solution based on doctrinal approach. I am going to propound here in this our discourse today, in this our session today, that now it becomes the responsibility of each and every state instrumentality and successive government to protect that freedom and freedom of conscience of each and every newborn baby in this Indian territory. It means it becomes the responsibility of state and state instrumentality, including parent, which we have also added that education in directive principle of state policy, adding the last fundamental duty, and in fundamental duty chapters in Article 51 capital A, we have also added the responsibility of parent to provide the education. But here what exactly we are saying, and we have also seen this is also responsibility of the state to provide the education to the children compulsorily. We have also seen that particular discourse by way of Free and Compulsory Education Act. We have also seen that particular discourse. We are not going in that particular, the box for discussion now. But here, now it becomes the responsibility based on this very important legal proposition which has been propounded by K.S. Puttaswamy, that freedom of conscience is also birthright of each and every individual. So automatically it becomes the responsibility of the state to provide the education, and the information of each and every religion of this entire world to the newborn child through this entire education system. To provide each and every religion's philosophy to that newborn child, or to that school going child, to provide each and every religion's philosophy or world religion philosophy, so that that newborn child, when he or she attain the age of majority, he or she will be in such a position to exercise her freedom of conscience. Freely she will be able to choose even any faith, any belief, or any way of worship. Try to understand, this is something is not going to happen, Something, it is not going to happen quickly. But if you will see carefully, analyze carefully, now emerging trend and emerging legal proposition and emerging, international discourse, you will find that this is also a new kind of jurisprudence, it is evolving. When we have recognized the rights of each and every woman, each and every, female, each and every LGBT peoples, and each and every male members of the society, their equality rights, we have to also recognize certain rights of those children as well, rights of those newborn children as well. And it has been categorically stated that it is inherent right of those newborn children or newborn child who born today to know this entire world, to know entire religions of this entire world. Then only he will be able to exercise that freedom of conscience. Because we have stated that freedom of conscience is part and parcel of human right from the birth. But how exactly we can exercise, or he or she can exercise when she or he will attain the age of majority? He will not be having any kind of free choice or freedom of conscience to choose any particular conscience or to choose any particular belief or to choose any particular religion. If it will be taught in a systematic way right from the childhood to each and every the citizens, each and every human beings, automatically a new kind of wisdom will grow. There will not be these kinds of problem like communal disharmony or their communalism, or more specifically we can say this different anti-religions or religious sentiments or anti-religions activities which are happening rampantly not only in India, all over the world. So this kind of problem, terrorism, hate speech, communal disharmony, these kinds of problem, and its a solution is hidden somewhere in this coming doctrinal research or in this coming new interpretation. Because no one will dare to approach before the Supreme Court for having this kind of new interpretation. But this is possible as well. This new kind of interpretation based on doctrinal approach, based on interdisciplinary approach, it is possible now. It is possible now that freedom of conscience of each and every newborn children, that should be kept protected right from the childhood. He should be taught not only that one particular religion, but he should be taught those all religions, so that he will be able to exercise his freedom and free choice of choosing the religions, choosing the belief, choosing the faith, choosing the worship, choosing the conscience. It is possible. But it is not, this much easy task, because lot of vigor, lot of, strength, lot of criticism, and then a lot of adverse remark, that will be definitely invited by way of this new kind of interpretation. But it is possible. It is possible. This new interpretation based on doctrinal approach, it is possible. Based on interdisciplinary approach, it is possible. Now, taking you ahead with reference to other important, the trends with reference to doctrinal approach, I have, cited in my some work, and I just wanted to, again bring back. Recently, we must have seen, dialogue, discussion, and lot of legal interpretations as well, which has stated that right to information is not applicable to ICC, Indian cricket, or more specifically those bodies who are not exactly getting fund from the state or state instrumentality. This particular the virgin legal premise, you must have coming across time and again. You also must have observed under Right to Information Act 2005, there are non-disclosure of information or non-disclosure clause as well under section 8 clause 1 subclause J of information Right to Information Act. Right to Information Act, you also must have come across, it is applicable against the government, it is applicable against the ministry, it is applicable against the government bodies, it is applicable against the public authorities, which is defined and designed in this this Right to Information Act 2005. So this is nothing but the background, or this is nothing but the existing literature now, or existing the doctrinal research which has been so far conducted now. But now the question is that, now you must have seen recently as well, the secrecy bond by the government of India. It has been issued to many corporate houses, that those funds which has been invited by political parties were given, a lot of funds, but those funds secretly, it has been given based on secrecy bond. This is something new analogy that has been evolved from the side of, the successive government or present government. But we have to also understand here one important legal premise and one important, important legal statement I am making here, that we cannot hold responsible to political parties and leaders who are outsiders of the government. Presently, situation is like this, that we can hold responsible under Information Act or Right to Information Act to those all public authorities or those all government, bodies. We can hold responsible to those all who are inside the government, or those all ministers and ministry which is inside the government. We can hold them responsible under Information Act or Right to Information Act. We can seek the information from them. We can ask them the information, provide this particular information to us. But the same analogy or same section, it is not applicable to those political parties who are outside the government. See here, the peculiar situation that one political party, large political party, we have almost 7 national political parties, and then we have almost 63 state political parties, and then we have 2064 registered unrecognized political parties all over the country. But it is peculiar, something peculiar, that one political party who is forming the government, and that political party's leaders who are inside the governments, to them we can hold responsible for asking the information under Right to Information Act. We can ask them the information. We can ask from them the information. The people from same political parties. Say for example, 100 people must be there, just for example, in one political party. Out of that, 50 they are in government now. Now 50 they are outside. 50 people or 50 personnel of the same political party, they are outside now as an outsider. Now, as a political party, they are not responsible under Information Act or Right to Information Act. So we cannot hold them responsible. We cannot ask against them any information under Right to Information Act. So here you will find that in this entire dialogue, discussion, and in this entire situation, all political parties, analogy is there, they are also, performing a similar nature of function, public function, or, public welfare related function, like government is performing the public welfare function. Different political parties, they are also performing same kind of function. They are also reaching to the society. They are also solving the problem of society. They are also eradicating certain problems. They are reaching to the government. They are facilitating their problem. So they are also, working on social welfare scheme, which is also being done by the government. Only they are not, getting the fund from the government, so that this particular, stand that they are not getting fund from the government, this should not become the hurdle for making and holding the responsible to those political parties, leaders who are outside the government. Because there is no intelligible difference here, that why we should not hold responsible to those 50 candidates from the same political parties who are outside the government, not holding any portfolio inside the ruling government, inside the, the ruling party and the party's personnel who are inside the government. So there is no intelligible difference here. Why we should left to those people or those candidates of the same political parties who are outside the government, just because they are not exactly coming within the definition of public authorities. So on this as well, electoral reform, or more specifically on this particular aspect as well, there is requirement of new kind of wisdom or new kind of interpretation, and it is possible because law is growing continuously. We are seeing that we are bringing many bodies, private bodies, within the purview of state instrumentalities. Other side, we also sees that we also examine that, we also see and examine this particular aspect. These all political parties, ultimately they are being registered by, or registered from the side of government only. They are being registered from the side of constitutional functionary by the election commissions only. They are being regulated by the governments only. So that deep and pervasive control is already there on these political parties. At last they are being asked that submit your proper assets, submit your wealth related information, submit your information related to your candidature. So that kind of regulation already it is there. Why not that should also be extended to make more and more accountable to those political parties who are part and parcel of this entire democratic process. This is one important, the new interpretation is going to come with the help of doctrinal approach and with the help of interdisciplinary approach in coming time. At the same time, when we are talking about this public governance, when we are talking about law, public governance, when we are talking about, more specifically our public administration, you have to also understand other important new discourse or other important new legal interpretation is also going to come into existence in coming time by way of doctrinal approach. That is nothing but we are continuously seeing that Law Commission of India, that report of 255th Law Commission's report has already stated something regarding electoral reform. We have also seen that a lot of important Law Commission's report, reformative measures that has been explicitly referred from the side of Supreme Court, in People's Union for Democratic Reforms in this particular case, People's Union for Civil Liberties in this particular cases. Supreme Court has also opined in this Ashok Chauhan versus State of Maharashtra cases with reference to this electoral reform process. But electoral reform with the help of human rights, with the help of fundamental rights, that has to be interpreted systematically. We have come to the extent of saying that freedom of speech and expression, or this particular fundamental right, is also inclusive of casting of vote as a freedom of speech and expression. But we have to travel beyond this. In doctrinal research, we have to travel beyond this particular, established legal norms. Because we are continuously talking about political parties, political rallies in the festivals of democracy, nothing but the election process. I call it as a festival of democracy. Those whatever election it takes place every 5 years or in between 2 years or 1 year in different states and at national level. So those election process I consider as festivals of democracy. So when these festivals of democracy, it goes ahead, political parties are the backbone of this entire democracy or democratic process. So political reform, wherever it is possible, it should become the legal norms. It should become, the call of the time. We are continuously seeing that, we are continuously talking about that public meeting is being held by this particular, the political party. When election comes, we generally observe this. We generally see that political rallies, it takes place, public meeting, large public meetings, it take place, different procession, it take place. We continuously see this in festivals of democracy, in election process. We generally see this. We generally see also in this process of public meetings where almost 50,000, 10,000, 20,000, 1 lakh, 2 lakh, audience, people, citizens, those are being addressed by the political parties. But this address which happen in this entire democratic process, it is always one-way track discussion. Nowhere this discussion is two-way track. So when we are talking about in democratic reform or electoral reform, that political party is also responsible to facilitate freedom of speech and expression. Going beyond that, political parties are also responsible to facilitate right to ask questions. Because that right to ask question, which is also one of the important facets of freedom of speech and expression. It is not limited only to right to information act, when application will be sent from particular person, when he is seeking certain information from the government body, then government body will write something in revert or in reply to that particular application, and then he will be sending back the reply as a information to that particular individual. This is not exactly right to information or right to or freedom of speech and expression and its intent. Its intent is not limited to only get the information by way of right to information act, or only get the information by way of certain means and mechanism. But right to or freedom of speech and expression also, or it is also inclusive to right to ask questions as well. Now the question is that in our democratic process, whether in democratic process, in these festivals of elections, festivals of democracy, whether political parties, whether really they facilitate this right to ask questions. Why not they should be held responsible? Why not election commissions and the central government, they should held responsible, and they should bring within the four corner of right to information act and freedom of speech and expression? Why it should not be made the mandate and responsibility of those political parties as well, that they should facilitate right to ask questions as one of the important facets of right to know and right to information and freedom of speech and expression? It is possible. Because so far, if you will go in your state of Kerala, in your Karnataka, in your Maharashtra, or anywhere, in festival of election, you attend any particular public meeting. Because if you will see the important definition of public meeting itself, from the Webster dictionary or from the encyclopedia, if you will take out that literal meaning of this public meeting, it is saying that it is two-way track discussion. It is nowhere mentioned it is one-way track discussion. Why only political party they should speak from one side? Why not from other side people? Let it be even 10,000 people, 1 lakh people. That is the beauty of democracy, to ask the questions to the their authorities or their political parties. Because nowhere it has been stopped in constituent assemblies and it's a discourse from asking the questions to their political parties in public meeting. Even silences of the constitution, because everything it is not coming, or it has not come in the constituent assembly debate. But political reform, successive governments, they should try to always keep in touch with the political reform, that particular, or electoral reform, that particular statement. Time and again it has also come in the constituent assembly discourse. So here what exactly I am stating, that continuously we are saying that freedom of speech and expression as a human right or as a fundamental right, it has to be facilitated in this democratic process. It is not only the responsibility of the state and successive government, it is also responsibility of the political parties as well. They cannot absolve their responsibility, or they cannot avoid their responsibility to facilitate these all human rights or these all fundamental rights. But nowhere and no one is giving thought on that particular aspect. No one is asking this question, very blindly and very, submissively we have adopted and accepted this secrecy bond, this particular platform which has brought from the side of government of India recently, which has allowed to, the political parties to take those all, secret donations from, different, we can say the corporate houses under the cover of this secrecy bond. And those political party, if they are taking, say for example, any national political party or state party out of the 7 national parties, if any party is taking, now you are not having any say to ask right to information against that particular aspect, because that is political party. Now question is that why not political party should also become part and parcel of that democratic process? Why it should not become part and parcel of that particular, the process, and that particular stakeholder who is also, performing, the public nature function or public welfare related function, which they are claiming, which political parties all over the, country they are claiming. They are doing the social work, they are doing the public work, they are doing the public welfare related work. So why this differentiation? Now differentiation very tactfully, if you will see, a political party sitting in the power, making a particular platform open for those political parties or its own political parties and its personnel who are sitting outside the government. From inside the government, they are making this particular provision, they are making this particular, secrecy bond, which will facilitate or which will provide the advantage or which will provide the benefit to those political parties who are sitting the outside or outside the government. Where is the intelligible differentia here? There is no intelligible differentia. Long back we have seen in Justice Tendulkar case how this intelligible differentia, reasonable classification, this doctrine, it has got evolved or it has come into existence. The object which has to be achieved by any particular act or any particular, plan or any particular legal policy, the object of that particular plan, policies, act, and then that classification which is being done, then the classification which is being done between the group of the people or between the things of the people, it should have a reasonable connection. It should have a reasonable, difference, means there should be intelligible differentia. Means we should be able to, connect that this particular, object which has been set by any particular plans, policies, and then the classification which has been made, it is having reasonable nexus or reasonable connection. But here, presently, I don't find any intelligible differentia in the stand which has been taken from the side of government of India. And your doctrinal research will bring a something new interpretation based on this particular aspect only. We have yet another important, aspect to discuss, but I find that we'll keep continue our dialogue discussion if there will be other session sometime in coming time. I find I should stop myself here at this juncture, providing this all kinds of input today by way of this particular session. But now house is open for dialogue, discussion, questions, queries. Indeed, I wanted to discuss and dialogue on certain important, the legal challenges. Quickly, in 4 or 5 minutes, I will, provide those important, the inputs related to doctrinal research, and then how interdisciplinary approach is also going to help, this your legal research. So recently we have also seen economic recession, and continuously all over the world, amid COVID-19 and post COVID-19, we are going to face this economic recession or somewhere it is affecting, the GDP of the country, not only India, all over the world, many countries they are facing this. But if you'll try to understand other disciplines, cost benefit analysis and then cost benefit analysis based infrastructure you can bring into existence, which will be more viable and which will save more economy of the country and exchequer of the country. In this context, viable solution for the governance and administration based on economic analysis, based on cost benefit analysis and information and communication technology, it can be infused. Let me give you the example that recently we have seen that our just shortly conclude giving certain new ways, new areas where interdisciplinary research, where more specifically doctrinal research, it can grow and you can bring that new kind of wisdom through your legal research. So as I was referring, that recently we have seen amid COVID and then post COVID as well, we are going to have this kind of problem with reference to impact on economy in India, all over the world, in other continent as well. But during this COVID, we have also observed and we have used this information and communication technology very systematically and very vigorously. Even justice administration, we have seen the Supreme Court of India, as soon as this lockdown it was called by the government of India, they have brought standard operating procedure, and with the help of the standard operating procedure, we have seen that this justice administration, it was happening with the help of virtual hearing, or we can say with the help of this cyberspace it was happening, or with the help of this internet it was happening. Similarly, we have also seen this cross examination of witnesses, or trial court as well, different high courts as well, they were conducting the process with the help of virtual hearings. So this was very much in a systematically and in a systematic manner it has been used. The same important platform to have augmentation of our economy or to save the exchequer of the country, it can also happen in the lawmaking process, because lawmaking process, physical lawmaking process, we cannot replace with this virtual lawmaking process, no doubt. But we have seen during this COVID-19 that many administrative decision making, it was happening through virtual hearing or with the help of virtual meetings. Our president, our prime minister was sitting in his office, and he was interacting for policy formulation during this COVID-19 with the president of Russia or with the president of other continent, and formulating the policy to tackle with this COVID-19. So information and communication technology, it had been used to larger extent. So the same platform, it is also as a viable solution, not as a complete viable solution, but it can be used and exercised in lawmaking process. Why I am saying here? Because I have observed by way of our one small project in our School of Law, when we filed this right to information to this legislative department of Government of India, we came to know by way of this right to information that for conducting the one-day physical session of Parliament, the cost of that is 20 crore rupees. 20 crore rupees. 20 crore rupees, which is inclusive of this 500 and odd member salary, their telephone, their conveyance, their security, their stay, their food subsidy, their conveyance, their phone charge, internet charge. So inclusive of this, all inclusive of this, that one day session when which we see through this Lok Sabha channel or news Lok Sabha channel or Rajya Sabha channel, that one day session which is taking place, that 5 hour or 6 hour session, that the cost of that is 20 crore rupees. So per minute cost of that session is 7 to 8 lakh rupees. So what exactly we have proposed from other disciplines, the solution to this, because there is no exactly problem, but something new solution, new important ways that can be adopted, that out of this 1 way, 1 month, the session, parliamentary session or lawmaking session, at least 7-day session should go through, the online mechanism or with the help of this online infrastructure, where all members sitting in their constituencies only, having a proper foolproof, infrastructure, having a proper server, they can connect in the parliament directly and they can have dialogue and discussion. In that way, we can, reduce the cost. In that way, we can reduce that hustle bustle. In that way, we can reduce that, particular, we can, and it is also more viable. So, and there is no exactly any other hurdle as well, because when justice administration, which is more sensitive, it was happening, through online process, then question comes, then why not then law making process should also happen, at least not replacing entire this particular physical, this law making process, but at least certain segment that can also happen through ICT or with the help of ICT, and it is cost benefit as well, or it is based on cost benefit analysis as well. This is possible, economic analysis in public administration and law making process. Similarly, economic analysis, other disciplines knowledge. In criminal law and sentencing, it can also happen, because now you must have seen in criminal law, in our country recently this trend happened, economic analysis, it is happening, but in European countries and in United States of America, economic analysis of criminal justice administration, continuously they started and it is happening. But economic analysis of jail administration, if you will take out, you will come to know that in trivial matters, many jail inmates, they are behind the bar, and the cost of that, it is overburdening over the state. So if you will do the economic analysis, it is always preferable those non-serious offenses, those jail inmates, they can be provided with certain fines, and based on that fine they can be scot free in the society. So that economic analysis is also possible in sentencing and criminal justice administration. So that is also yet another important ways to think in doctrinal approach. Adaptation of artificial intelligence in criminal justice, criminal cases and civil cases. Issues of delay in justice administration. Continuously we are talking about trial courts are overburdened with many litigations, many cases we are talking continuously. But European countries, many Western countries, they are adopting artificial intelligence. We have to also think regarding artificial intelligence adaptation. Process started in our India, but that process is very slow. But we have to think now speech recognition software, where judges or trial court or chief judicial magistrate is speaking, need not to repeat once again, need not to have again recording by way of stenographer. That can be properly with the help of speech recognition software, with the help of artificial intelligence, directly it can be recorded as a record, and then it can be properly rectified and corrected by the judge. We are not talking here about replacing the existing court managers or court management system, but to make it speedier, criminal justice administration, artificial intelligence can be infused, speech recognition software can be infused. Besides that, even artificial intelligence, with reference to recording these all court proceedings, examination of witnesses, it can be taken into account. So that is very much possible with the help of doctrinal approach, with the help of interdisciplinary approach. this kind of research it can come in coming time. Mental and psychological health also influence decision making of judges. Very few research in our India, even none, nil I am telling, it has been conducted so far. In European country, University of Oregon, they are conducting research based on even the mental health, how exactly it is impacting the decision making of the judges. This research is happening there. Psychology of the judges. Even Benjamin Cardozo long back had stated that even subconscious mind, even antecedent, precedent, antecedent, family, history of any particular judge also impact and influence the decision making. Even the judge is coming from the poor strata of the society. He may be having different, the wisdom to decide the cases. If the judge is coming from the affluent family, he may be having, something different approach to decide the cases. So that kind of research is also possible by way of, the psychological, the domain or subject matter infusing in the legal research, and with the help of doctrinal approach, it can be conducted. We have also seen how beautifully environmental engineering that has also been brought back in the environmental pollution reduction and prevention. We have seen this polluter pays principle, and then preventive, more specifically precautionary principle, polluter pays principle. Those principles are ultimately based on environmental engineering only. That precautionary principle is based on environmental engineering only. That the measures at the beginning of the pipe should be taken by the developer or that industrialist. This is the approach from environmental engineering that had been infused and used at the international level when this Rio Declaration on Environment and Development that had been decided and that had been agreed upon in Rio Conference in Rio de Janeiro in 1992 by way of principle 15 and principle 16, principle 15 of Rio Declaration on Human Environment and Development. Principle 15 on precautionary approach has taken the account of this environmental engineering only. That precautionary approach has to be taken into account for protecting the environment or protecting this human environment and for development. So see, these are certain important, the areas you can think. And obviously, when a doctrinal approach you are using, legal propositions when you are using, you have to also keep your eyes and mind open. What is exactly happening in other disciplines as well? What is happening, in the psychology? What is happening in, in the economy? What is happening in the public administration? What is happening in the international, affairs? What is happening in at the international level? Because international discussion and dialogue is also tremendously impacting the law making in our country and legal research in our country. So with this, I will stop my this this session today, and house is open for dialogue and discussion, question and answer.
Thank you, Azim sir, for the extremely knowledgeful and energetic session. We have some questions in the chat box. Shall I read it for you, sir?
Yes, please go ahead.
So first question is from Dr. Krishna Kumarji. And the question is there any difference between interdisciplinary legal research and socio-legal research?
All right. As I have stated that social or socio-legal research, when we are talking about, that is one of the important segment of interdisciplinary research. Because when we are talking about interdisciplinary research, we are not talking about any one particular discipline. We are talking about the varieties of discipline which is impacting the law, which is impacting the growth of the law, which is impacting the wisdom of the judiciary, which is impacting the wisdom of the existing knowledge base. Socio-legal research, when we are talking about, I remember the wordings of Professor Upendra Bakshi at this juncture. He says that law cannot be understood or understood unless and until we are not understanding the society. So to understand a proper functioning of any legislation, we have to understand the psyche of that society. Why that particular, the law in particular remote village related to the dowry, it is not working properly. We have to understand the psyche of that particular society or that particular segment of the society. So socio-legal research, when we are conducting, no doubt, this is one important approach where we will be understanding what is exactly inside the mind of the society and how exactly it should be taken into account in the legal norms. Most of the time, we don't take into account the societal experiences. The existing legal system, I am telling you, even if the law is being, discussed in the parliament, no doubt, we see many references from the society. Okay, all right, these many incidents of, hate speech happened. These many incidents of, this cow vigilantism, it has happened. So, okay, we are discussing that there should be something law. But that is not the complete picture. Most of the time, society is continuously talking and speaking something. It has to be understood by the lawmakers, because now the situation is like that. Law has to be in a real time, because law has to match with the real time. Gone those days where there was, slow process of the society, slow process of different disciplines, slow process of the legal norms. Now that is not the case. Now quickly, today one new software is coming, today one new satellite is going in the air and space, in the space. We have to have regulation just now, immediately now, with reference to that. So first of all, we have to understand, if societal problem, if it has to be resolved, we have to, or we have to, if we have to understand why any legislation or why any particular legal norms is not working properly, we have to understand the societal experiences. So socio-legal research is one segment, no doubt. But when we have to, understand the problem, that one particular surgeon sitting in the America, he performed the surgery over the patient of the India. At this particular juncture, you have to understand the other disciplines knowledge base. Interdisciplines knowledge base you have to understand. You have to understand how exactly or how much percentage of incision or cut he has made by way of that particular robot, which was, being regulated by the computer program from his office or from his, a hospital, when he was sitting and performing that surgery in United States of America, or from United States of America, or the patient in the India. So to evolve that kind of, regulations, we have to have other disciplines knowledge. If you have to take into account, if you have to resolve the problems with reference to, say, for example, this environment pollution, we continuously talk about. Now, if you have to solve the problem of this climate change, now many scholars, they are talking about now climate emergency is required for entire world. But climate emergency, if we required for entire world, we have to understand a certain policy norm we have to establish. We have to provide a proper statistic. We have to provide a proper, scientific evidences as well. So we have to see that discipline to bring this legal norm or any statute or any world, we can say the international declaration on this climate change or legally binding document after United Nations Framework Convention on Climate Change. If you have to bring something new which is legally binding document, we have to have the analysis and we have to have a proper other disciplines knowledge from that scientific discipline domain. We cannot only have the opinion of socio-legal, research. We cannot only have the opinion of society. Here at this juncture, you have to have the opinion and the scientific database from the science or from the science field. From meteorological field, you have to have the data and analysis to establish that, see, really, this 2 degrees Celsius mean temperature is, now getting increased, and it will be, more, hardship and more, fatal to many, human beings and, entire, human creatures on this planet Earth. So interdisciplinary research obviously will provide the input to bring a growth in the legal wisdom and to bring out the new legal norms.
So next question is from Aliyar. The question is, how far socio-legal research is working on social reforms in India, where majority of educated people are looking for migrating to Europe, Canada, or even US?
Yeah, very, very important and very good questions. Social legal research continuously in sociology, domain as well, it is happening. Now see, at the same time, we have to also understand, as you have quoted, that migration and European country, uh, uh, the family institutions, they are, now marching ahead and they are relocating. There are many factors, many reasons responsible behind this. Now, as we are already saying that entire, world has become global village. So in that context, we have to also see and examine everything open, right from education to employment. Everything is open, now. There is no exactly, now border for this. So accordingly, society and, societal experiences are also getting developed to, especially in the context of, getting citizenship from other countries and, relocating in other countries for employment purposes, for, education purposes. But see, this is the continuous process, because we have to recognize, certain important bottom line as well, as far as concerning to, as you are saying, by way of your sociological research or socio-legal research, and from the domain of socio-legal research, this problem of relocation, resettlement, and taking employment from abroad, it is continuous process. It is also vice versa. The people from, India is getting employment in other, continent. The other people from other continent, they are also getting the employment in the Indian continent. So this is the continuous process. But your question and your important, say is here, that socio-legal research and then this migration related issue which you are talking about. See, migration, this is not something, this recent phenomenon. This is from quite time immemorial. Continuously it is happening, right? If you will see our ancient time, if you will see our and examine our Indian experiences as well, this migration, resettlement, relocation, it is continuous process, because two different objectives are there in relocation, resettlement, or changing, we can say, the indigenous place. One is employment, other is, education. This is more main and major. Earlier, in earlier centuries, we have seen that was more and more related to colonization, more and more related to, power acquisition. But we are not talking about in this recent or this 21st century, where more and more, democratic setup of governments, they are working. So here the object and purpose in relocation and migration, and in socio-legal research, whatever factors and reasons which are emerging, it is reflecting more and more certain reasons. Either it is more related to employment or it is related to education. So those factors are, and those are related to ultimately human rights. No one can stop it. We cannot stop the Indian people to go abroad and take education. That is their freedom. That is their, right. That is their fundamental right. So this is one thing I just I wanted to pinpoint here.
Sir, we have one more question.
Yeah.
Question is from Varun Dev. He asked that how far we be able to include judges' judicial process in a research topic to make a detailed study over various aspects that could compel a judge to arrive at that decision and reason with it.
I have given just recently in our in my talk as well one important discussion point, because see, judge is ultimately dependent upon the wisdom of we can say the counsels, or wisdom of the advocates at last, right? because no doubt judges has to at last use their wisdom based on the current running discourse, current established legal norms and previous established legal norms, right? That is his work or her work. But see, many judicial pronouncements also become, or judgments also becomes, trendsetter. Means we should be able to connect those the dots, because legal research, doctrinal legal research, is ultimately connecting the dots, connecting between those or amongst those different legal propositions which are established as a established law or declared law from the side of judiciary. Either it may be persuasive precedents from other jurisdictions, or it may be our authoritative precedents of our own hierarchy of the court or courts, including high courts and Supreme Court. Here, one thing I already pinpointed here. See, if you keep open, your minds and eyes, automatically you will be having a deductive reasoning. I am telling you, deductive reasoning, because in doctrinal research, deductive reasoning is very important. Automatically you can exercise the deductive reasoning. From particular instance, you can have a generalized principle. How it can happen and how you can use in your research elaborately, I am telling you. Deductive reasoning, we have stated that it's just like based on one particular legal proposition or two particular legal proposition or three particular legal propositions, you are going to bring out something new interpretation in a general form or as a general interpretation or new interpretation. Just like, here, the case which I was referring, that is Fahima Shirin versus State of Kerala, Justice Asha. Now, Justice Asha, and now from this particular case, you can have something new interpretation or new legal research as well, based on just this one particular case I am telling you, with the help of other cases as well, no doubt. See, Justice Asha said that fundamental rights, human rights can be properly exercised, with the help of internet, with the help of, the cyberspace. Because even, United States of America, United Nations Organization 2016, while bringing this particular, we can say resolution, they have also stated further that whatever as a human rights are available offline, that should also be available online. This is one legal proposition, very important legal proposition. Now, other side, Justice Asha in Fahima Shirin versus State of Kerala is saying that right to education, right to life cannot be exercised unless and until you are not getting information, unless and until you are not getting, education through internet. So that should become part and parcel of right to education, and that should be recognized, right? So see, the facilitation of fundamental right or protection of fundamental right is happening with the help of cyberspace or internet, right? Till here we now reach. Now, what we are arguing, the new interpretation before the Supreme Court, or in coming time, definitely it will be there before the Supreme Court. We are saying that, we wanted to say that and that I did not refer in my particular, this particular discourse, but now let me refer in this, as you have asked this particular question. We traveled like anything from decade of 70s, 80s, 90s, where human rights, where we have seen, Akhil Bharatiya Soshit Karmachari Sangha case, judges transfer case, where we have seen the new approach it has come with reference to enforcement of fundamental right. This locus standi, it had been liberalized. The interpretation of Article 32, it got liberalized, right? We have seen earlier rigid approach, it got changed by way of Akhil Bharatiya Soshit Karmachari Sangha case, saying that Justice Bhagwati there had stated that now poor people, they cannot approach before the Supreme Court because they don't have means mechanism. Even they are not aware about their fundamental right. So it is just like they are not having any kind of fundamental right if they are not able to approach before the Supreme Court. So our rigid approach of locus standi, it is becoming hardship for their fundamental rights enforcement or their protection of fundamental rights. So rigid approach got liberalized based on this particular statement or legal proposition that now any public spirited person on behalf of those disadvantaged people can approach before the Supreme Court. Now that was ultimately to facilitate the fundamental right, to protect the fundamental right. Now look at to this 2021, 2022, 2021, 2022, 2020. This is again related to access to justice. We have seen this entire world, it got connected with the cyberspace. Even one side, Supreme Court is saying, okay, you just go and have, live streaming, make known to the people so that people will know. Other side, Supreme Court itself, not only in India, Canada, other European country, they were, conducting virtual proceeding. Justice administration was going through virtual proceeding. Access to justice, right to life, right to legal aid was also facilitated through or with the help of internet and interface of virtual hearing. So see, now if you read that 80s decade, this liberal approach of ABSK Sangha, where Supreme Court recognized that any public spirited person can approach before the Supreme Court. Now, new role or new interpretation is also getting, infused, or it can be interpreted based on these all available legal propositions. Now, even, earlier, later petition, it had been adopted, accepted by the Supreme Court. Now I am saying even the video petition can be accepted as a matter of fundamental right enforcement from the side of Supreme Court. Video petition, direct video which will be sent to the Supreme Court related to any problem or hardship or violation of fundamental right, it has to be accepted, it has to be enforced, it has to be provided with the remedy from the side of Supreme Court. Because this can also become part and parcel of, enforcement of fundamental right under Article 32 of the Indian Constitution. It can also become part and parcel of access to justice. Because we have traveled from rigid approach of locus standi to liberal approach of locus standi. Public spirited person can, file a petition on behalf of those persons. But now we are saying that now that aggrieved person can record his concern, can record his concern, can record his violation of fundamental right which he is not getting, his proper water or hygiene if he is not getting in his region, he can directly record that and submit to the Supreme Court, because Supreme Court has not given any hard and fast formula as a proceeding which has to be adopted and accepted under Article 32. So this new interpretation of video petition as a access to justice under Article 31 can also become reality in coming time. So accordingly, you have to also bring out the new solution, new ways, new thoughts, new interpretations by way of judicial interpretation or judicial, or we can say legal propositions which has reflected or which have reflected in different judicial precedents.